Welcome, everyone, and thank you for spending your time with us this afternoon. We hope to provide some understanding of the complex legal issues surrounding these recent horrific killings of Black unarmed citizens. I am Karen Saltzman, Program Manager in Psychiatry and co-chair of Stanford Staffers. I am going to introduce Kevin Hutcherson, who will then introduce our speaker, followed by a moderated Q&A using your previously submitted questions. I met Kevin at some roundtable events the Black Staff Alliance held in 2012 and 2014 in the aftermath of the killings of Trayvon Martin and Michael Brown. These roundtable events allowed staff and students to educate ourselves, share a space, and process our grief together. We hope to hold a similar event as soon as possible when public gatherings are allowed. Kevin is project manager in lands, buildings, and real estate for the past 27 years and is chair of the Stanford Black Staff Alliance, whose mission is the concerns of Black staff on campus. Kevin has a great passion for helping others, and this is also reflected in his mentorship of young men in Oakland. I'll now turn it over to Kevin.
Thank you, Karen. And hello, everyone. Thank you for joining this important conversation of the current policing and criminal justice system in America. Providing the narrative this evening will be Professor Robert Weisberg, who founded and now serves as faculty co-director of the Stanford Criminal Justice Center, which promotes and coordinates research and public policy programs on criminal law and the criminal justice system, including institutional examination of the police and correctional systems. He has written on topics including homicide law, regulation of police, prisoners' rights, and capital punishment. He formerly served as a consulting attorney for the NAACP Defense Fund, litigating appeals in death penalties. Following Dr. or Professor Weisberg's talk, Dr. Jennifer Cohen will join him in a Q&A of the previously submitted questions. I'd like to provide a little background and bio on Dr. Jennifer Cohen. She is Associate Director for the Biosciences Diversity Programs in the Stanford School of Medicine, Office of Graduate Education. She's a retired cellular and molecular biologist. She is passionate about increasing equity and inclusion in higher education and has devoted her career to creating inclusive communities for the underserved to achieve their full potential. In 2008, Dr. Cohen developed a comprehensive graduate student report model for creating community for unrepresented students. Her solution for improving learning environments remains a resource for the recruitment and retention of diverse students in higher education today. On that note, I would like to now pass it on to Dr. Weisberg for his narrative.
Dr. Weisberg, please unmute.
Thank you, Kevin. Thank you, Karen, and other colleagues who have been involved in setting up this event. I'm flattered to be asked to do this. I want to first note the limits of what I will do. The issues we're going to be talking about today are tragic, horrifying. They raise unbelievably fundamental issues about morality and justice in the state of our government. I don't have any comparative advantage over anybody else here in terms of the proper sense of moral justice. What I hope to do here is provide a legal context, because so much is being discussed and often misrepresented in the media about what the actual legal framework is under which these deaths are being investigated and crimes being prosecuted. And I also want to say that inevitably, given the variety of people's sense of moral justice, there will never be a perfect match between legal outcomes and those senses of justice. I hope that doesn't lead to cynicism, though, because there's a significant overlap. And in any event, where law feels like it is falling short of justice, we should look forward rather than backward, if possible, to see what changes in law might enhance justice. Now I'm going to get extremely technical, though, about some of these cases. And I'll start, of course, with the death of Mr. Floyd in Minneapolis. We've all heard public debates and lots of conflicting information about what the charges are against the police. And of course, those charges have changed day by day. The current situation is that all 4 officers were arrested. They have all been formally charged now, but the charges have some complexities to them. When the first charge was announced against the main perpetrator, Derek Chauvin, it was announced as third-degree murder. And there was a lot of distress about this because the very term third degree sounds, well, because it's not the first or second degree, like it's diminishing his culpability. Now, it's important to see that while the legal system uses terms that evoke various sentiments, we have to think of these not as sentiments, but as technical legal terms. It appeared as of a few days ago that the case that would be made against Chauvin was that while he did not intend to kill George Floyd, he showed a horrible kind of reckless or callous indifference, as if he was going to engage in a sadistic act, and it probably crossed his mind that it could be fatal, but he just didn't care. And that would have been the basis for something in Minnesota law that's called depraved indifference murder, which they call third degree. Now, again, the nomenclature and the numbers are rather arbitrary. In fact, the exact same crime would be treated as second degree murder in California. There was an understandable outcry that because this crime was so horrendous, it should be first degree, because first degree sounds like it signifies about as awful a crime as people can imagine, and that's what Chauvin's crime seems like. But it would have been impossible, probably impossible, to charge Chauvin with first degree murder under Minnesota law, because it would have required not only proof beyond a reasonable doubt that he intended to kill, but that he had done so with cool premeditation. Now, it turns out a couple of days later that the charge was raised to second degree murder, which normally involves intent to kill but not premeditation. But the prosecutor in this case, and this is an interesting point, no longer the county district attorney in Hennepin County, but the state attorney general, Mr. Ellison, pointed to another component of second degree murder. And it's a very complicated legal one. We even discussed this in our classes a lot, but I'll give the simple version of it here. And that is, even if he didn't intentionally cause the death resulted from an act of his which was itself a violent felony, namely aggravated assault. This is the so-called felony murder rule, and it usually applies when the felony, which as we put it, is the predicate for the killing, even if the killing is accidental, it can become murder, is a felony like burglary or kidnapping, something that's separate from the actual assault. But in some states, not all, but it turns out in Minnesota, a felony like the assault can serve as the predicate. This gets the case up to second degree murder. The sentence for these charges could be very, very high. It could be as high as 40 years on the second degree charge. Now, it is very rare that anybody gets the maximum sentence. There are some formulas, some of them dependent on prior crimes by the defendant, but some other factors as well. But if he's convicted, we will not know the sentence until the judge exercises his or her discretion in that sentence. I think it would be a very long sentence, but I have no idea what it is. Now, that's the situation with Derek Chauvin. We waited several days, of course, to hear what I think was inevitable, that the other officers would be charged. They have been charged with essentially the same crime as Chauvin. We hear about aiding and abetting, and there's often this notion, well, that's a different crime. It usually isn't a different crime. It's simply a different way of committing the same crime. Even if Chauvin is the only one, of course, who put his knee on Mr. Floyd's neck, if the other officers encouraged or enabled him to do so, or did not exercise their legal duty to intervene when they realized what Chauvin was doing was horrendously illegal, it is as if they had their knees on his neck as well. The fact that they didn't do the physical act may not matter very much. So they are susceptible to, in theory, the same charges and the same sentence that Chauvin can get. Will they get that? Very hard to say. They're going to tell different stories. We know that two of them, turns out, were rookie officers who had just started, and they've already made statements saying that they were terrified by what Chauvin was doing. They said something to try to stop him. That may or may not lower their culpability somewhat, but it's unlikely that it would exonerate him. So we will have to see now what's going to happen in Minnesota. And by the way, these murder charges and manslaughter charges stack up in a kind of vertical continuum. So of course, the jury might wind up convicting any of them on a so-called lesser included offense within that hierarchy. It's very hard to predict at this point. Okay. The death of Ahmaud Arbery, the horrible case in Georgia, is really different. It's not a killing by a police officer. It's a killing by a few wannabe police officers. Now, in the background here is this old and probably anachronistic thing called citizen's arrest, which perhaps should have disappeared a long time ago, but it hasn't. In theory, a citizen, and here it simply means any private person, can mimic the work of a law enforcement officer under certain circumstances, can actually arrest someone, which means, of course, hold the person until the real authorities show up. If this sounds like a bit of Wild West vigilantism, yes, citizens' arrests have often turned out that way. Here is the supposed limit of it. A citizen can arrest a person if the citizen, I'm using that term loosely just to identify the right scheme of characters here, if the citizen observes a serious crime while it's occurring. Now, there are more complications than that, but that's really the gist of it. And can only use serious force to arrest if the crime they observed was itself violent, or if the alleged criminal is exhibiting a threat of violence to the citizen or others. Now, what is the supposed crime that Mr. Arbery committed? This is a big mystery. There were these reports, quite up in the air and unclear, that as he was jogging, he quote unquote trespassed on some private property. It wasn't a residence, it was some kind of building under construction, I believe a commercial building. Well, yes, if he entered that building without permission, one could say it was a trespass. I don't know if he did. But trespass is hardly a serious crime. It could only be a serious crime if it turned into a burglary, which would be a trespass normally into an occupied building, especially a home, with the intent to commit a crime inside. And there's no evidence that that's what happened here. That's a story that the defendants are telling. So even if they could make the case that Mr. Arbery went onto the property without permission, one possibility here, by the way, is that he was just looking for a place with some water while he was running. They probably don't meet the criteria for a legal citizen's arrest, and therefore they had no legal right to take any action against him at all. More significantly, at the time of the fatal encounter, a few minutes later, and now we know, of course, it may have involved one or two other people in addition to the infamous McMichael family. Certainly at that point of the fatal encounter, Mr. Arbery was not committing any crime at all. He was jogging on a public road. So first, they would have to come up with an almost ridiculous argument, that he was still in the process of committing or escaping from some horrible crime, which he wasn't. Even then, even if they were allowed to use a little force to seize him and hold him for the police, they certainly couldn't use deadly force unless he was exhibiting a threat of deadly force. How could he? He was jogging. Now, their only other argument would be that they did intend merely to exert some moderate force against him, maybe just to seize him with their hands. They had guns, which they will say they legally possessed. Yeah, I guess that kind of gun is legally possessed in Georgia. And therefore, the presence of their gun wasn't a big thing, except that they will argue, I think they may argue, that Mr. Arbery, in response, tried to grab the gun, and they, in turn, felt they had to use deadly force against him, however ironic this seems, in self-defense against his threat. Clearly, the Georgia authorities, now up at the state level, see very little credibility in any of these potential defenses by the McMichaels. They are being charged with murder, and although we need not go into the nuances, Georgia murder law is a lot simpler than Minnesota law. It's really just plain murder. Clearly intentional murder here because they, fired a gun at him. They are going to face murder charges. They are facing murder charges, and it remains to be seen if the other two characters in this scenario will as well. The death of Breonna Taylor is different still, and it's in a very unusual context. The background, as you may know, is that the police claim to have had probable cause that her boyfriend, Mr. Walker, was involved in some kind of drug crime, and that there were drugs in the apartment where Breonna Taylor and Kevin Walker were staying. The police got what I will call a facially valid search warrant. That's a bit of legal jargon. They went to a judge or a magistrate. They got probable cause. They had probable cause to believe that there were drugs in the house. So they were allowed to exercise the search warrant. Now, the background rule for search warrants is that the police, in order to avoid disturbing the peace, have to knock on the door, give the residents a reasonable amount of time to open the door peaceably, but also announce that they are police officers. Under certain circumstances, a magistrate can issue a so-called no-knock warrant, where there is reason to think that the process of knocking will do one of two bad things. Number one, alert the residents so that they might quickly destroy the evidence. There's always this myth that people are going to flush all their drugs away, or that knocking will precipitate a violent response from inside the house by the residents. I don't know if the judge had a basis for adding the no-knock part of this. I don't know if they had any evidence that there was any threat of violence, and this obviously was, from what I can tell, a pretty generic drug investigation. In any event, the police went in. There is some dispute about whether they bothered knocking anyway. They went in, and Mr. Walker, who legally possessed the gun that was in his hand, and he now says this, he has survived, says that he was afraid that he and Breonna Taylor were about to be the victims of a terrible attack. He fired at the intruders. He did not know they were policemen, okay? He was wounded by the police. They fired back, and in their spraying of bullets, they wounded him and they killed Ms. Taylor. Now, the argument will be here that by some combination of a faulty warrant and faulty execution of the warrant by the police, this may be a violation of the Fourth Amendment against unreasonable searches and seizures. If so, there is the possibility of civil liability, possibly big damages against the police department, although that's little consolation. Can the police themselves be charged with crimes? And by the way, Mr. Walker was originally charged with aggravated assault and attempted murder against the police. Those charges have now been dropped, which leads one to think that the police in Louisville were satisfied that he acted in self-defense, and that would suggest that the police didn't. Now, what can happen now? In theory, the state authorities in Louisville, Kentucky could charge these officers with murder. There's no sign that the authorities have any intention of doing so. The officers, as I understand it, are on administrative leave, but they haven't been charged with any crime. On the other hand, the FBI is investigating this case. Now, quite independent of state authorities, under certain circumstances, federal prosecutors can characterize a local crime as a federal crime as well. Indeed, in theory, the feds can come in to the killing of Mr. Floyd or the killing of Mr. Arbery. There are various crimes called civil rights crimes and also federal hate crimes, so that the feds could step in instead of or in addition to what the state and local authorities do. My guess is that the likeliest source of criminal prosecution against the police in Louisville, those who killed Ms. Taylor, will be the federal authorities, because the state authorities have seemed so reluctant. That's the big picture here. There are many other moving parts to this, but I want to now allow my colleague Jennifer Cohen to step in, because there are some other issues to explore. I hope I've made a good start in just setting the legal stage for how the justice system currently could address these issues, but I'd be happy to discuss any number of other matters, such as additional legal or administrative or legislative means of addressing these sorts of offenses, and also perhaps some speculations, and they can best be speculations, about what outcomes will unfold in these cases. Thanks.
Thank you, Professor Weisberg, for educating us on the legal issues related to these unjustified killings of George Floyd, Ahmaud Arbery, and Breonna Taylor. Today is National Gun Violence Awareness Day, and with the ongoing protests against police brutality, calling for justice, our collective awareness is centered on these racist police shootings. As cited by mappingpoliceviolence.org, last year, US police killed nearly 1,100 people, and Black people were 3 times as likely as whites to be targets of police violence. Despite representing only 13% of US population, Black people made up 24% of those who were killed. 99% of police killings over the last 6 years have not resulted in criminal charges, making this injustice even more violent, and this conversation even more urgent. To those joining us today, thank you for choosing to be here, and thank you to each and every one of you who submitted questions prior to today's webinar. We've organized your submissions into categories that will frame the next portion of Professor Weisberg's remarks. And those categories include law and legal policy, power and influence, and ending with calls to action for tangible and meaningful change. Professor Weisberg, today, June 5th, is Breonna Taylor's birthday. She would have been 27 years old. Breonna's family filed wrongful death lawsuit 2 months ago against the 3 police officers involved with Breonna's shooting, and they're on administrative leave. First question, why haven't these officers been charged with any crimes?
I can only say that the local authorities, it starts with the district attorney in the relevant county in Louisville. It could go up to the state attorney general, as it has in other cases. I can only guess that they don't believe that the police committed a crime. They will say that the entry into the house was legal because it was authorized by the warrant. Maybe it was. There's a separate question about whether there really had been probable cause for the warrant or for the no-knock component of it, but that remains to be seen. The second argument, now I'm imputing this, of course, to the prosecutors there. The second argument would be that especially because they had a no-knock warrant, they were permitted to enter with guns, and they were firing in self-defense because Mr. Walker shot at them. This is a very, as we say in the trade, very fact-specific question. It's significant, though, that the FBI has come in. They may have been invited in by the local authorities. It doesn't matter. They can come in under their own power. If one believes that the local authorities simply do not have enough objectivity or independence or fairness to assess the situation fairly, well, this is a common argument for why federal prosecutors may step in. They are independent. Federal judges are not elected. They're certainly not elected by anybody local. Federal prosecutors are appointed by the Department of Justice and the president. They don't respond to local political interests. So let's wait and see. Maybe federal charges will follow. It's theoretically possible that state charges will follow, but I wouldn't be optimistic about that.
Thank you. United States laws for murder vary by jurisdiction, and in most US jurisdictions, there is a hierarchy of acts known collectively as homicide.
Yeah.
So first-degree murder and felony murder are the most serious, followed by second-degree murder, voluntary manslaughter, then involuntary manslaughter, and lastly, justifiable homicide. Right. Now that officers are starting to be charged, what are your cautious predictions for outcomes that might be brought against the police officers involved, in particular with George Floyd and Breonna Taylor's cases?
Well, in the case of George Floyd, we know that the charge is second degree. I don't think it's going to be higher than that. But again, that could carry a 40-year sentence. I want to say something about enhancements because that raises the question of racist motive, not just the racial disparity, which you've mentioned in terms of the larger statistical picture, but racist motive in a particular case. You've all heard about hate crimes. That's a big, broad category. And it could, for example, turn a very minor assault into a felony if a minor assault was otherwise motivated by racial bias. In a homicide case where the sentence could be here or here or here, in most jurisdictions, there can be a hate crime enhancement whereby if the jury otherwise decides that Mr. Chauvin is guilty of either second or third degree murder, a certain number of years can be added if they can establish he was racially motivated. The racial motive enters in as well if the federal authorities come in. First of all, because there's a federal hate crime law. Second of all, even independent of hate crime, the usual way that the feds come in, at least when they're busting local police officials or police officers like Chauvin, is the older tradition that it's federal jurisdiction because the defendant, in this case, Officer Chauvin, had the intent to deprive the victims of their constitutional rights, which in this case technically means their rights under the Fourth Amendment. That kind of blends in a way with the racial hatred motives, so that can go up there. Okay, now, it is very, very risky to make predictions. So with all those caveats, my guess is that Chauvin is going to be convicted of a murder charge. I don't know whether it's going to be I don't know whether it's going to be second degree or third degree. If there are doubts about the evidence and if the jury has a certain view, it could go down into some kind of manslaughter. I doubt it, but it's possible. The other officers raise a different issue, or a possibly different issue. Even if they're charged with second degree murder or maybe third degree murder, these can still be amended. If they're viewed as having been, to use a little jargon, grossly negligent, culpable but grossly negligent in not intervening. In other words, they didn't exhibit the grave, depraved, sadism that Officer Chauvin did, but they were in a position where any reasonable officer would have said, we've got to stop this right now. Then some version of involuntary manslaughter is conceivable.
Thank you. What are your thoughts, Professor Weisberg, on advice for responding to people who use the victim's past to vilify and or attempt to justify killings?
People can say whatever they want, but it is completely legally irrelevant what kind of background Mr. Floyd or any of the other victims had. It's only relevant, and even here it isn't really relevant, if he were exhibiting some kind of behavior which would justify a violent response by the police. That, if it were true, could justify what the police did, or at least mitigate the severity of what they did. If it turned out that Mr. Floyd was being violent, I'm sure people would do some journalism, perhaps bad journalism, and trace this back to some bad character on his part, bad things he had done before. But that's just that would just be background biography. It doesn't matter. The police didn't know anything about his background. I don't think they did. And even if they did, that wouldn't matter. They can only respond to his behavior at that particular moment. So it is legally irrelevant. It doesn't matter if he's a very, very flawed human being like most of us are. It doesn't matter if he had done bad things in the past. It could just as well be the world's most saintly person. It's the same thing.
Another question regarding law and legal policy is, why is it just so difficult to convict police officers on offenses that normal citizens would be jailed for quickly?
Well, first of all, people will contest the question, although I think it's an important question because in other words, it's a question of whether we're comparing similar things. And police certainly face challenges because of their duties and exposure that many people, most people probably don't face. And I think most police officers, this sounds almost like a cliche to say, but I will say it, I work a lot with police officers, and I think the great majority of police officers are serious, honest, moral people. But if we talk about the institutional situation, remember, first of all, that popular perception, which doesn't directly decide things, but it indirectly decides things, tends to favor police a lot of the time. The other thing, though, is that who prosecutes the crimes? Prosecutors. Yes, the federal prosecutors can come in extraordinary cases, but 90+% of crime in the United States is prosecuted by county district attorneys. And they don't necessarily, I'll put this very generously, have an approach to police that's very objective and independent because they are partners with police in investigating and prosecuting crime. It sounds like the beginning of the Law and Order episodes, of course. They are famously not as objective as they should be. And what I want to emphasize, it's a kind of in the weeds legal point, but I think it's very important, and I'll just brag a little and say my colleagues at the Stanford Criminal Justice Center have done some interesting research on this. A very good policy, which has been adopted in a few places and should be adopted everywhere, is that when an officer, it could be a county sheriff or a municipal police officer, but somebody within the local jurisdiction, is charged with a crime against the citizen, the prosecution and investigation should not be done by the county district attorney. And I'm putting aside the feds. It should be done by the highest level within the state. And in this case, in the Mr. Floyd's case, it is being done by Attorney General Ellison. And it's being done, I think, in a parallel way in the Arbery case. That seems like a very technical distinction. It's a very, very important one.
Thank you. Continuing along this vein of discussing power and influence, as citizens, how can we advocate to have police officers and law enforcement officers and departments better trained to be public servants that de-escalate incidents and avoid violence? Well,
there's political power involved, and I know people feel very disempowered, but who are the police? Most of the police in the United States work for municipal police departments. Certainly they do in big cities. If you take, let's just take at random Santa Clara County, where some of us are sitting right now. The big cities and the mid-sized cities have their own police departments, San Jose, Santa Clara, Palo Alto. The sheriff, who also plays the role of the jailer for the county, becomes the kind of default police officer for the unincorporated parts of the county. Well, police chiefs are not elected, but they're appointed by elected city councils and by mayors. County sheriffs are elected in most places. So the ballot makes a difference here. It really does, but it takes a very well-informed public. Second, most jurisdictions have at least thought about various kinds of civilian or civic review boards, and they've had mixed success. But there's always the possibility of a citizen review board being given some power to monitor. In drastic situations, but we've got a lot of drastic situations, if a lawsuit is brought by the victims of police violence and the lawsuit calls for damages or more likely an injunction against the police to reform their methods, what happens sometimes is, particularly if the lawsuit is brought in federal court, the judge can actually impose a kind of receivership on the police department, sometimes called a special master or judicial monitor. The city of Oakland, which has had some recent small successes lately against the background of awful corruption and violence, has been under a federal court injunction for a long, long time that resulted from a private lawsuit brought on behalf of victims of police misconduct. That is a lever as well. The last thing I'll say is that there is just plain legislation. So for example, if you thought there should be a law setting a higher standard by which a police officer could justify a killing, that's part of the penal code in the state. That has to go through the legislature, or alas, and I'm saying alas because I'm not a fan of the initiative process in California, it may have to be done by popular initiative. There was a new law passed last year which purported to set a higher bar for police to be able to use deadly force. It became a compromise and it became very controversial. The original part of the bill emphasized that a police officer could not use deadly force unless he or she had exhausted all reasonably available alternatives, so-called de-escalation techniques. That ended up very much softened in the law, but the law as in the one that was passed, but the law as originally proposed is a model for what might be undertaken in other places.
Could you tell us a little bit more about that, around deadly force, this deadly force bill?
Well, here's a way of looking at it. We always tend to see these things, and I mean literally see them because we're seeing them on camera. And oh, by the way, let me just add that although there are pluses and minuses to body cameras, number one, I think the pluses outweigh the minuses. And number two, as with most technology, it's going to happen anyway. So certainly filling the gaps in places where there aren't currently requirements for the use of body cameras or car cameras by the police, that itself is a step, because there's a lot of accountability. Sometimes we get it through the random phone videos, which are happening almost everywhere. So I just simply wanted to add that point. But let's get back to de-escalation. An officer might have the legal power to do a so-called stop or detain on you or to frisk you, okay? The officer might have the power to arrest you if she has probable cause to believe you've committed a crime. There's kind of a sliding scale of tests she has to meet for that. This is to say that the police could legally do X. It doesn't mean the police has to do X. Police exercise discretion all the time. They think this is minor, it's not worth causing an encounter. Heck, let's go back to the killing of Breonna Taylor. I don't know, nobody really knows that much about the circumstances, but was the drug crime they suspected was going on there and the significance of the drugs in the house, were they that serious that you needed cops to go in and with guns blazing? So when we see the final moment of encounter, let's just assume for the moment, to give the benefit of the doubt to the police, that at that moment a police officer, rightly or wrongly, reasonably perceived the person was threatening the officer with deadly force. But could the police officer have taken steps earlier so that he never would have gotten into that quandary situation at the last moment? Will the police officer say, well, I legally stopped him or I legally arrested him? Maybe you did, but you didn't have to do those things. If you say to yourself at the point of the stop of the arrest, I have the legal power to do this, but I'm afraid that exercising that legal power could escalate things catastrophically. Let me freeze the situation, call in backup, step back, maybe even walk away if the crime isn't that serious, but I'm afraid the reaction would be. I think most police reformers think we have to move in this direction. The difficulty is writing a law that could require this sort of thing.
Thank you. What are some possible effects of jury selection?
Huge. Juries have to be unanimous. They have to be unanimous for guilt, but interestingly, they have to be, in most places, in California and Minnesota, they have to be unanimous for not guilty as well. There are many layers of jury selection. We all know that what jurors bring into the courtroom will affect their ultimate behavior. Not entirely. People are not determined by their background interests. I think most juries are pretty fair and deliberate pretty fairly, in part because the jurors who won't do that are usually winnowed out. But there's a lot of strategizing about jury selection, and there is a long, tragic history of racial discrimination in jury selection. Very often it operates at the initial stage of the jury pool, who even gets summoned to the courthouse. Then there is the very controversial area, which has all kinds of constitutional issues associated with it, whereby the lawyers, and we tend to focus on the prosecutor, can exercise so-called peremptory challenges against certain jurors. They are not legally allowed to do so on the basis of race, but proving that that was the motive for doing it is hard when, you know, you're allowed to ask jurors all kinds of questions about your background and, you know, associations and things like that. But in close cases, the jury selection can make a difference. The jury selection in the case of Minneapolis, for sure, is going to be incredibly scrutinized, and we'll see what happens. But yes, it can make a difference.
And when should these cases be prosecuted at the state level, and when should they be prosecuted at a federal level?
They should always be prosecuted at the state level, but I mean, the two are not mutually exclusive. They should always be done that because these are crimes under the penal code of the particular state. The feds tend to come in, I mean, in theory, they could come in at any time if there is a federal violation, which there would be if it's the crime was motivated by the desire to take away somebody's civil rights or meets the federal hate crime standard. But generally, the feds come in when there's a failure of state law. Let me give you some old fogey background on this. In the awful days of the killings in the South in the 1950s and 1960s, killings of civil rights workers, both African American and white, there were, take the infamous Birmingham bombings of the poor school children. Sometimes the state officials didn't even bother prosecuting. What happened in a number of these cases is that they were just, you know, joke trials where criminal charges were brought and an all-white jury just acquitted in about 10 seconds. In those days, the federal prosecutors brought down by the Federal Department of Justice would come in, and many of the people who were acquitted or never even charged by the state authorities were convicted under federal laws. The police officers who beat Rodney King were acquitted in state assault trials, a very controversial trial. They were then convicted of this exact thing. 18 U.S.C. 242, federal civil rights crimes. The officers who beat Rodney King were convicted and sent to federal prison. But that was because of a perception of the failure of the states. The real action shouldn't be at the federal level. That's a kind of backstop. The real action should be, first of all, of course, better selection of and better training of police. And second of all, better prosecution by independent-minded state prosecutors.
Thank you. Recently, there's been an increase in elected officials who are denouncing campaign funding that has come from law enforcement unions, donating that money to nonprofits and community organizations that are geared towards fixing or improving the criminal justice system. So what specifically can be done to put a stop to the power of law enforcement unions?
Well, I'll leave to my constitutional and First Amendment colleagues the question of the legality of actually forbidding contributions from police organizations to elected officials. But of course, nothing stops an elected official or a candidate for elective office from just saying, I'm not going to do it. We know that, I believe just in the last day or two, not a prosecutor, but the state senator in San Francisco, Scott Wiener, announced that he will no longer take police contributions, and he's giving the money back. Parallel, we're talking about police, of course, but there's been a long history in California at the correctional level where the once very powerful CCPOA, the Prison Guards Union, it's a lot less powerful than it used to be, had a huge influence over criminal law and sentencing policy in California. There was a governor a few terms back, named Gray Davis in California, an otherwise liberal Democrat, whose entire campaign funding depended on contributions from the CCPOA. Schwarzenegger didn't need their money. Jerry Brown didn't take their money. I'm quite sure, quite positive Gavin Newsom didn't take their money. So that's the prison guard side of things, but I think there are parallels with the police. In fact, there are arguments, frankly, when we get to prosecutors, and by the way, judges as well, who are elected at the county level, that maybe they shouldn't be elected at all. They should be appointed, but at the very least, I think we're going to move in the direction of that kind of limitation.
Thank you. We haven't yet really talked about civil damages. Can we switch our gears to discuss possible civil damage suits?
They're very hard to get because of a doctrine which people learn about in law school called qualified immunity. Let's just step aside from the current situation and understand the rationale. Police officers, and this isn't true of just police officers, it would be true, for example, of prison guards and other state or local officials. They have to make difficult choices, and if they feared that upon a wrong choice or upon what retrospectively looked like a wrong choice, they could be sued and bankrupted, they would be very, very inhibited in what they do, and that would be bad. Let's just assume that as a big general principle. The result of it, certainly with police officers, is something called qualified immunity. And in very simple terms, it actually isn't much more complicated than this. In general, it's just a question of how it plays out on the facts. Let's assume that there are standards under the Fourth Amendment for what constitutes excessive force. And among other things, Officer Chauvin is said to have engaged in an unreasonable seizure, if you will, an unreasonable action under the Fourth Amendment. To get damages from him, it is not enough to show that he was wrong. It has to be shown that what he did was so wrong that he couldn't have conceivably reasonably believed he was right. I know that's a funny formulation, but it really means that it has to be an extremely egregious violation. Lawsuits against the county, or whatever the relevant entity is, the police department, Hennepin County, the city of Minneapolis, I guess it would be here, might be easier to get, but the government only becomes a defendant if it can be shown that, I mean, generally there's some nuances to this, if it can be shown that the government is really responsible, not just vicariously for the actions of, they'll say it's a rogue cop, but rather liable because of a demonstrable failure to train or monitor or recruit properly, and so on and so on. On the other hand, as with any kind of civil case, if it's dramatic enough and controversial enough, these things do get settled. It would not shock me at all if the city of Minneapolis settled relatively quickly for a humongous amount of money for Mr. Floyd's family, and possibly parallels elsewhere.
Professor Weisberg, we have 416 people who have logged in to listen to your remarks. I want to give you some space before we move into our final question to take your time and tell the people who joined this conversation what it is very important for them to understand for these times.
Well, I feel a little daunted here. I lack wisdom on the larger scale. So Jennifer, I'll revert to some more specific things. Who makes the laws here? State legislators. So let's do a little, everybody take a quiz. Do you know who your state legislator is? Most people don't. Do you know who your chief of police is? Do you know who your mayor is? This may all seem indirect because we react to things that have happened in the moment. But this is about government action. Admittedly, the Arbery case involved wannabe police. So even then, of course, just imagine a law that simply repealed the power of anybody to even claim citizens arrest. But focusing on the Breonna Taylor and the George Floyd killings, where we have actually police officers. Police officers are members of the executive branch, but they sit under the power given to them by legislatures, and they sit under the power of higher officials in the executive branch. At some level, these people are elected, but they tend to be unknown. District attorneys who want to get reelected are famous for never having any contested elections. They're district attorneys for life, just kind of de facto. So while you're concerned about the most immediate things, get involved in local government. That's where almost all the action is. I also want to say something about people at Stanford, not just students, but people involved in any parts of the overall enterprise here. Obviously, people at Stanford can participate as citizens in any of the ways that any citizens can. The comparative advantage of being at a university is that directly or indirectly, you're actually involved in teaching and research. And I want to put the emphasis on research because some reforms just seem like they're morally commanded by an obvious sense of justice, for sure. But some reforms really depend on research because there are a lot, in my program, we work a lot with very good faith police departments who want to know how to improve what they do, and they want to better understand the consequences of various policy choices or reform choices. Things like, should we use electronic surveillance in various ways and all that. People in a research university can help fair-minded reformers get research help. And I'd encourage anybody who's involved in any kind of research program to think about how, depending on the discipline you're in, it could be almost anything. It could be in medicine, it could be in social sciences, it could be in engineering. You could play a role that way.
Thank you. In addition to hiring a more diverse workforce that reflects the diversity in our great country, what are some other essential actions that institutions like Stanford can take in order to make change happen and to affect change at the national level?
Well, again, I'm going to say something about research. I know it sounds like a rather dry subject, but there's so much bad information out there. There's so much mythology out there. There's so many, there really is fake news. It's not the fake news that's denounced as fake by a certain person. The fact is there are gross misunderstandings, like, for example, the racial disparities in terms of who is stopped by the police are really racially neutral because they're perfectly consistent with the actual crime rates based on race. Now, there may be some correlation, but there's a lot of circular reasoning going on here. So, for example, if the police are attacked, I shouldn't say attacked, I'm sorry, if the police are criticized because some humongous disproportion of people stopped on the street or in their cars, we all know the famous driving while black phenomenon. If a disproportionate number of them are people of color, the police will say, well, it so happens that they are actually committing crimes to a disproportionate effect. Well, but how do we know that? First of all, those statistics are questionable, certainly with drug crimes. Second of all, the idea of who has committed crimes is a function of who is being investigated for crimes. If police go to certain neighborhoods and direct a disproportionate amount of their resources in certain neighborhoods, yes, they will find poor people of color in those neighborhoods, and they will say, well, we're arresting them because, or seizing them because they're committing all these crimes. But that's a significant function of where they were looking in the first place. So that there's a kind of circularity to a lot of these statistics. Now, it's a complicated matter, but the point is, although public officials very often say, oh, statistics are just done by these, crazy liberal academics, blah, blah, blah. Okay, well, the fact is that social science tells us things when our intuitions or our perceptions are downright wrong. I'll give one more example of it. When people start voting for tougher law and order stuff, harsher sentences and all that, they almost always justify this by saying that they experience the sense that crime is going up in their neighborhoods and in the United States. Crime in the United States has gone down dramatically in the last 30 years. The crime rate in the 2000s is, putting together a lot of different components of this, 60 or 70% lower than it was in America in the 1990s. The homicide rate in almost all the big cities is 30% of what it used to be. Nevertheless, get a politician out there and the politician will get people to think that crime is going up. Most people in most comfortable places at least, don't experience crime very directly or have no sense of the amount of it. They're fueled rather in this attitude by their general kind of political or cultural attitudes. Social science is very imperfect, but it can really speak the truth sometimes.
With that, thank you, Professor Weisberg, for sharing your research and expertise and for spending this time to help both educate and activate our greater Stanford community. Thank you.
Thank you.
I want to thank our host organizations, the Black Staff Alliance, and Stanford staffers. A special note of gratitude to Karen Saltzman and Kevin Hutcherson. Thank you for your leadership in bringing this conversation to the forefront. I also want to recognize and shine gratitude towards Jessica Meyer, today's webinar host. Jessica is Stanford event manager in the School of Medicine Research Office and also the co-chair of the Stanford staffers. On behalf of Professor Weisberg, Karen, Kevin, Jessica, and myself, thank you. Thank you for joining us during this really devastating time. Please remember to complete the post-event survey to share your feedback and thoughts on today's webinar. We want to recognize that many of you are oscillating between exhaustion and being enraged. So please be sure to do more of those things that you find joy in. Take the time to find your balance, to rest and renew your mind and your spirit. It's a priority. Self-care is a priority. And it's a necessity to allow each of us to do what we can to change the systems that we've discussed today and to demonstrate that Black lives matter. Thank you.